Good afternoon, everyone. Can you hear me in the back as well? Okay, good. Thank you very much. So thank you so much for inviting me back to the University of Leuven. Last time I was in Leuven, this time here in Brussels on campus. And I must say, when I was in Leuven in February or March 2016, I had just drafted the first chapters of this book and had the opportunity to test some of my ideas on a group of very well-trained lawyers and economists. And it was enormously helpful for me to think about how to rewrite the book, and I rewrote it probably 2 or 3 times since. So I hope even for those of you who were there at the time, this still will sound somewhat fresh. I'm just going to walk you through some of the conceptual ideas that the book presents. I will not walk you through the entire book. I will just use 2 case studies to show you how law helps to code capital, or how capital is really coded in law. And then I will talk a little bit about globalization, whether or not we could actually have a global system that is coded in law, whether my argument makes sense. I will talk a little bit about the masters of the code, the lawyers, in particular the private attorneys amongst us, and then talk about the political economy or the policy dilemmas that we might face at the end of this. So here's the basic framework. So what is capital? I'm following Piketty and others who are basically saying capital is an asset that has some potential to generate wealth, private wealth, that is. And so the question for me is, what enables a simple object, a simple idea, or a promise to future cash flows? What makes it possible to generate private wealth from that, right? And so my answer to that question is actually that's the law. The law flips a simple object, an idea, a promise to payment into a wealth-generating asset. And how does it do that? It basically helps graft to these objects, ideas, or cash flows onto these assets. And I use the term asset here loosely as a general term for capturing objects, ideas, and cash flows. So I'm basically saying there are 4 important attributes that we have to think about. And you need usually 3 out of 4 to flip a simple asset into a capital asset. And here they are. First, priority. It's all about ranking. And it's, of course, we know this from property rights and other aspects of the law. If you have stronger rights, you're better off than if you have weaker rights. So what the law does, it ranks different types of claims. You can't hear? Okay, let me hold this closer. Oh, sorry about that. So the law ranks claims to assets. That's what priority is all about. The second attribute is durability. Durability extends these claims in time. And that's an aspect that is very often underestimated, and I'll come back to that, because it's not only important to have better rights, it's also important to be able to protect these better rights over time, even in times of crisis. Then there's universality. Against the lawyers amongst you know what I'm talking about. This is when we're thinking about absolute rights or other legal titles that the state or a state court will enforce against the world, erga omnes. The whole idea is this is not a contract between you and me, between 2 bilateral parties, but it's a right that you can enforce against others who were never at the bargaining table, but who nonetheless have to yield against the better right? That's what universality is all about. And then for financial assets, durability might be less important in terms of just keeping a pool of assets together, but convertibility becomes key. And convertibility doesn't mean simply tradability or assignability, but convertibility means that I can flip my asset into a safer asset. We see this in crisis all the time, the run on cash or the run on dollars. Why that? Because there are some assets that can retain their nominal value, and these assets are typically state-issued currencies. They don't necessarily retain their real value. We might have inflation, but state-issued currencies are the only financial assets that retain their nominal value. All privately issued financial assets can lose their nominal value, and they tend to do this in a crisis. Okay? So these are the 4 attributes. And I'm basically saying, very simplistically put, give me any object, any promise to payments in the future, or any idea, and I will flip them into a capital assets by grafting these attributes, at least 3 out of 4, onto these assets. Okay? So the legal modules that we have used for the past 400 years or so to do precisely that have remained remarkably stable. So I started, as Professor Herrmann suggested, I started my research really after the global financial crisis in this area and first unpacked basically complex derivatives instruments and tried to understand the legal structure. And what I found looked remarkably familiar. You find property rights, you find collateral, you find trust, the common law trust law, you find corporate law, you find bankruptcy law, and you find contract law, which can mimic many of the features of the other areas of the law. Contract law is the most flexible, but if you get the contracting parties around a table. So these are the modules, as I call them, of the Code of Capital. You can also call them elements. So just one word on the term of code. I'm not talking about codification. I'm really talking about the process of coding capital, of grafting these legal attributes onto different claims or different objects or onto ideas and thereby create capital assets. So why do I need law for this, and what do I mean by law? So what I'm basically saying is that law is a particular institutionalization of the coercive powers, of centralized coercive powers. That's what the state is, and that's how we have institutionalized law. And in the West, we have institutionalized law at least in 3 dimensions. So the first is familiar to all systems that claim they have some law. It's basically the state orders its citizens how to behave or create certain constraints, etc. Right? So top-down ordering is one dimension. In rule of law-based constitutional systems, we also have the bottom-up, where citizens can use the law to protect their interests against the state, their property rights, their freedom of speech, their religious rights. So this is bottom-up, but it's also vertical. The dimension that is very often overlooked, which I look at in this book, and which is critical to me, is the horizontal relation, which basically means that private parties can avail themselves, can employ the coercive powers of the state to organize their own private relations. And that's critical. So to the extent I can have access to state power, I can organize my private relations many more ways and probably more powerfully than I could otherwise. So this citizen relationship, the horizontal relationship, is really key for me in this book. And the assets that we have slated as capital over time by grafting the attributes of capital onto them have been land, firms, debt, and know-how. And these 4 assets I discuss in the book. So I've devoted a chapter to each of these different assets. I've added here data because this is my current research project. Data obviously is the next oil, as some people say, it's the next gold. It's a new type of asset that has somewhat different characteristics than the other assets and also defies some of the legal classifications that I have here. I'm happy to respond to that in the Q&A, but that's basically the current mode of research that I'm in. I just wanted to put this up here to get you thinking about this as well. So how do we think about data as a capital asset? I will talk about land this afternoon, and I will then go over and talk about debt. I will skip firms and know-how. Again, I will be happy to come back to this in the Q&A, but I also want to make sure that we have some time for discussion at the end. Okay? I can skip this. I already said this. We're basically grafting these different modules onto the assets. So let me start with coding land. So I motivate the chapter on land basically by talking about an unusual coding exercise, which is the coding of the centuries-old use rights that the Mayas of Belize had as property. So in 2007, the Supreme Court of Belize recognized centuries-old collective use rights in land as property under the Belize Constitution. And it took a very long time to get there, but I use this case for 2 reasons, or for 3 reasons. The first is just to show how legal reasoning works. How do you make a claim under a constitution that says this is property and this is not? And you basically come as the Mayas, if we have collective use practices, we want them recognized as property. They're not zoned, they're not titled, are they property? What does the Belize Constitution say? The Belize Constitution, like many other constitutions in the world, say property rights are protected by the Constitution. It doesn't say what property rights are, it presumes them. Also something to recognize, we have a lot of pre-constitutional, pre-legal power relations that we then recognize in law. What we recognize and what we do not recognize is a fundamental decision that we make, and we have to think about who should make that decision. So in this case, they basically said we want this to be recognized as property. They had some other provisions in the constitutions that said that the indigenous people should be protected, their ways of life should be protected. That's all what the Constitution or the Supreme Court of Belize built on. On top of that, it took us property law, which is below the Constitution, said property is defined very broadly in that statute, so we just recognize this as property. That's the first reason I took this case, is to contrast the Maya of Belize with the commoners in 16th century England. Because in 16th century England, there was a dispute about whether the commoners had priority rights to the land or the landlords, who had better right. And as you all know, is that the landlords came out as having better rights. So the collective use rights of the commoners were not fundamentally this different decision made back then, and of course that had a major impact on the development of capitalism. And the third reason that I took this case as an introduction is to show that even though the Supreme Court of Belize recognized the property rights of the Maya, the state did not throw its coercive powers behind that, but continued to give license to mining companies to take the resources out from under the land, because the state tends to actually protect those who promise future wealth better than the state has protected other types of interests. So that's just as by way of introduction. The bulk of the chapter is really devoted to enclosure movements, and I use relatively recent historical research in England that suggests that the enclosure movement really started in the 16th century. By early 17th century, about 2/3 of arable land had already been disclosed. This was long before the major enclosure acts were passed. And most of the enclosure took place in a highly decentralized fashion, whereby landlords and commoners fought over who had access to the land. So they used to share it under some share practices. You could have it in the winter. The commoners could herd their cattle on the fields, or in the summer the lords could close the fields and use them for cash crops. And all of a sudden the landlords would not allow the commoners to graze their cattle on the land anymore. And so then the commoners went back, they broke the fences, they broke the hedges, it was violent on the ground, and then they went to court. And they had to make the case who had the better right. Now, don't forget, there was no clear precedent for that at the time, because they had this long use practice of sharing the land. There was no titling system. England introduced a registration system for land only at the end of the 19th century. So the question was who had the better argument? And the argument that won the day back then was seniority. The landlords basically said we had always better rights. We just agreed to share, but we had been there for better rights. We've been there basically first and therefore can claim the land. That's ultimately the argument that won. Then I'm taking the same dispute to the settlers' colonies of North America, New Zealand, Australia. And of course, there, the argument of seniority is difficult to make because there's no doubt that the first people were there first. So the argument shifts, and we of course know that. We do this in law all the time. We use analogy, we use different types of argument. And the new argument that helped the settlers, the white settlers from the West, basically get their use rights of the land recognized by courts, of course English courts, as property rights was improvement and discovery. Improvement is the John Lockean argument. If I combine my labor with an object, then I should obtain property rights in that object, like in land. I improve the land, I grow crops, it should be mine. It's a wonderful, also freedom-enhancing kind of argument, but we should not forget that John Locke was an official of the British government at the time that he wrote the treatise and made that type of argument. Discovery is more a territorial claim, a sovereign territorial claim, but goes in the same direction when they discovered the land and therefore had a sovereignty type of claim to the land, which enabled them also to pronounce who might have the better property rights. So that's just by way of showing how property rights have been created at different points in time. That's pre-registration, it's pre-constitutional, it's certain legal arguments that win in a particular context in courts. What do? They give you priority. Priority rights, that's my first attribute for capital. But priority alone doesn't win the game in terms of turning something into a capital asset that can generate wealth over time. It gives you better rights over others, but it's not necessarily durable. And that's exactly what the landed elite in England found out. And so what they did in the next step, they learned how to entail their land. They basically took an old institution from more the feudal times and said to their creditors, basically, when they came and tried to claim the land, because of course once you have title to the land, you monetize the land. That's what you're supposed to do in a capitalist system. You give somebody a mortgage, you get a credit, you build something, or you use the money to build your commercial enterprise, but you lever up your land. But when the creditors come after you to try to seize the land from you, you basically argue, actually the person with whom you entered into your debt contract and that gave you the mortgage is not the real owner. He's just a life tenant. He holds the asset for future generations, which is why under the old feudalistic principle, you can seize at most 50% of the land and never the family mansion. And that law remained in place until 1881 in England. And that entailment gave English landlords durability because they could protect themselves against the creditors. Now, is this efficient? Not in the long term, right? It gives you durability, which is nice. You can produce private. Is if you only hold the land for future generations, you can't invest. And they did not invest as much as they could. And then England also repealed the Corn Laws, so products from North America came in and they couldn't withstand the competition. So in the end, you had a major agriculture crisis in 1870, and in 1881, finally, England introduces a land reform, the reform of the land of realty, and basically declares that the life tenant is an owner, and therefore creditors can seize all of the land. For the family mansion, they still required approval of other family members or as a substitute court approval. After that major change in 1881, the Land Settlement Act and the Land Conveyance Act, almost 20% of all land changed hands. It was one of the most important redistributions of land in the history of England. And I'll just show you where you can see this right here. This is a picture from Piketty's book, Thomas Piketty's book on capital in the 21st century. And when you look at sort of the black, big hunch there at the bottom, that's agricultural land. That shows you that until the end of the 19th century, agricultural land was one of the most important sources of wealth. You already saw other sources of wealth, other assets come up at that time. One is urban housing, that's the light gray, and the rest, the dark gray, is other domestic capital. On the top you have net foreign capital. But when you look at the kink at the end of the 19th century, you see the effect of stripping land of its durability. That happened when we declared the life tenants to be owners and gave creditors the ability to seize all the land. There was no protection left. The land no longer was durable and thereby lost its attractiveness as an important capital asset. Then I also bring this story into a comparison in sort of debt enforcement between North America in this 18th century and England in the 19th century. I just said that in England they reformed the land only at the end of the 19th century. England enacted the same reforms essentially 150 years earlier in North America. In 1732 they enacted the Debt Recovery Act, which basically told the English settlers in North America and what would become the United States that they would treat all debtors as full owners of the property, and they busted the major estates in the south of the country in particular. So the issue with English land law, the law of realty as they called it, was not that they didn't know how to create an efficient property rights regime. It's that the entrenched interests were such that the landed elites wanted to protect their land against their creditors. They wanted to have a durability, and they were able to generate a lot of wealth from protecting their lands against too many creditors. They lost in the end, right? But it took a while. And in the meantime, before you lose, you can make a lot of money. In North America, they busted these estates. They also figured out how to protect them against. They used very similar devices later on, the trust and property rights, etc. Okay, so this is, you can see this is the United States, same book from Piketty. You just see that already in the late 18th century, rural land doesn't have the same significance as a source of wealth anymore. Other domestic capital, and here we're talking about shares, bonds, other financial instruments, become the most important source of wealth. Let me just say one point here which is also important. I don't really tell a story of staged capital development in my book, so I'm not saying first comes land and then comes firms and then comes debt. There's a lot of co-evolution. But I want to make one important point. When you talk about land, or when you talk about a machine, or when you talk about a cow, that object is still worth something and usable in a certain way without any legal coding. We would still recognize a piece of land. But intellectual property rights and financial assets only exist in law. They have no life outside the law. And so we have basically created a system increasingly whereby we even create assets in law and then basically enrich them with additional attributes to turn them into wealth-creating assets. So the system becomes incredibly self-referential because we're creating the very assets that we then determine to be capital assets in law itself. Okay, I will skip this also because that slide doesn't work well, and I will just jump into this slide, which is basically a story about how to mint debt, how to use debt as an asset that helps you create enormous amounts of wealth for the creditors. So we have basically also seen a shift, and you see this in the end of the 19th century in Britain, a shift from protecting landowners and their capital, that was land ownership, to protecting creditor claims against the landowner. So basically we've shifted the emphasis on what types of assets we're protecting. And of course then you get different iterations of that, and here is basically the story about asset-backed securities and collateralized debt obligations, the stories that we all know, of course, from the financial crisis. So I'll just walk you through this quickly and then come to the other bigger issues of the book. So on the left-hand corner you see these little houses, and this is basically an image of homeowners in California. You have a mortgage originator that is New Century, an originator that already went bankrupt in the spring of 2007. That's very, very early. They originate thousands and thousands and thousands of mortgages and then sell them wholesale to a major bank, in this case to Citigroup. It's a Citigroup affiliate. I simplified the graph a little bit. It's already complicated enough as is. So it's a Citigroup affiliate. And then what they want to do is they want to basically throw all the mortgages into a pool and then sell interest against the pool to investors, right? That's the idea. It's a pass-through model, and you want to sell it to investors so that you diversify the risk of these mortgages. What do? They use a trust to separate the risk associated with the assets from the risk associated with Citigroup or its affiliate. So the trust basically makes this bankruptcy remote because we're basically saying, investors, you don't have to worry about Citigroup because the assets are no longer in the hands of Citigroup, they're behind a particular legal veil. So I said earlier on, we need property rights, we need trust law, corporate law, bankruptcy law, collateral law, and contract law. What we see here is the use of trust and or corporate law to insulate assets from different groups of creditors. So what is a trust? A common law trust is a triangulated relationship whereby the original owner, the settler, transfers formal title to a trustee. The trustee has formal title and has to manage the assets but does not enjoy the economic benefits of the assets. The original settler, if his personal creditors come and want to enforce against the asset, can say, I no longer hold title to these assets, even though the original settler might still use it, but he no longer holds title. The trustee, when the personal creditors come running his way, can say, I have the title, but I don't enjoy the economic benefits. The economic benefits are for the beneficiary, which in the old days would typically be someone who would indirectly inherit from the settler. So upon his death, then the asset would be transferred. In this case, it's just our investors who become the beneficiaries, and they may not have the asset yet, which is why they can also protect their claims against their creditors. Having said that, you can immediately see why the trust has been the most ubiquitous legal instrument to protect people against all kinds of creditors, including state creditors, including the tax authorities. So it's the most widely used instrument to this day. So you have this trust, and then you sell interest against the trust, which is basically cash flow claims against the trust, right? Because you basically take the mortgages that the homeowners pay, they are serviced, they are being put back into the pool, and from these pools, the investors are being paid. Now, when they first started with asset-backed securities in the early 1970s in the United States, the government-sponsored entities and the government-owned entity, Ginnie Mae and then Fannie Mae and Freddie Mac, they created securitization. When they did this, they created a very simple structure. a trust. They also used the trust. And then investors would buy a slice in the trust, the same cross-section, just a bigger slice in the pie or a smaller slice in the pie. When the private sector took over securitization in the 1980s, the first private securitization came around 1978 or so, they developed a technique to attract more investors. Right? So the whole asset-backed securities machine became a machine that was all about scale. More mortgages, more investors to sell this off and live off the fees that you generate. And what they did is they used contract now to slice and dice the claims against the trust into senior tranches and mezzanine tranches and junior tranches and sell them to different groups of investors. Thereby they could make sure that they always had enough demand for the assets that they created. In this particular case, Fannie Mae buys one of the super senior tranches, China Investment Corporation, Bayerische Landesbank from Germany, BNP Paribas, they buy senior relatively safe tranches in the assets. Then you have some mezzanine tranches and you have some junior tranches, which are typically being picked up by hedge funds and others that like risk, or that are placed with the sponsor because they think they can do an interesting private placement later on, which they sometimes were not able to do. There was always one problem, however, with the securitization structures. The lower mezzanine tranches were hard to sell because they were not risky enough to give you the yield, and they were too risky for many investors that needed either by regulation safety or that wanted to have greater safety. But you can't really have a successful securitization machine if you can't ever place the lower mezzanine tranches. So the industry basically cloned its own buyers. How do you do this? You set up an entity, this time a corporate entity in the Cayman Islands that gives you tax advantages. And you raise funds from investors by saying, we will now invest into a cross-section, highly diversified portfolio of lower mezzanine tranches. Then we apply probability calculus and argue that the probability that all of these assets will default at the same time is sufficiently low. Such a set of tranching, there are senior rights you can buy and junior rights that you can buy, and mezzanine rights that you can buy, upper and lower. And of course, then again, you might not find investors for the lower mezzanine. What do you do then? Then you create CDO squared. Then you just go through the whole thing again, you create another entity. And there were also CDOs cubed, as you know. So this is basically how you can use a series of asset shielding devices, just stacking corporate or trust shields on top of each other to lure investors into a structure by promising them a lot of legal safety, a lot of legal certainty, because they just buy rights with certain priority rights, right? They might have a collateral to it. They all think that they can somehow enforce against the house, which is an entire different can of worm of legal issues that I won't get into here. But the point here is when you look through this entire structure, you find land rights, property rights, you find collateral, you find trust law. I can go into, if you want, also bankruptcy in particular, when we then go into derivatives built onto some of these structures. We have bankruptcy safe harbors built into that. We, of course, have contract, which is used to create these structures inside the trust. So the point here is, again, that we can use law to create value, right? And without these shielding devices, you could have never created as much value as was created with their help. I will skip intellectual property rights again, and let me turn to the other issues I wanted to emphasize. So I've told you so far that capital is coded in law. I've made the argument that a set of private law institutions have been used for centuries to code capital. And of course, the counter-argument has to be, well, private law is domestic law. We live in a global capitalist system. How can you possibly have domestic law sustaining a system of global capitalism? It makes no sense. We don't have a global state, we don't have global law, so the argument falls apart. And my response to that challenge is, in theory, we could have a single domestic legal system that sustains global capitalism, as long as all other states recognize the legal features that are created under that system and enforce them. Right? That's basically conflict of law rules, of course, right? So if most states do that, we could have a single legal system. In practice, I would suggest that for financial capitalism, we have two legal systems that do most of the work. England, English law, and the law of New York. And you can throw in for corporate law, Delaware as well. So we have actually not a highly diversified thing. Neither is it in the cloud, as many people imagine globalization to be, nor is it 1,000 flowers bloom, but it's a very parochial system of coding. It's actually rooted primarily in two important legal systems, the laws of England and the laws of New York. So I gave you that argument already. Of course, it's happening mostly through conflict of law rules. Here in the European Union, of course, we're trying to do a lot of legal harmonization. I was at the Commission this afternoon and discussed these issues with them. And of course, the attempt there is to create a level playing field so that people would really focus on competitiveness about economic things, not about regulatory arbitrage and legal arbitrage. My response to that was basically, I fear that you cannot win that game, because especially in a sector that is as deeply coded in law and regulated top-down as well, having a legal or regulatory advantage is what this is all about. So the idea that you can create a legal playing field and people would stop trying to play legal or regulatory arbitrage is naive, because that's where the value is. Which doesn't mean that we shouldn't try and do some of it, but we can't really find all solutions in that practice. Okay, which brings me then to who's done it. And the argument, of course, and you heard me already, is that much of the work here is done by private attorneys. They use the law that states make available. And again, the emphasis here is on the institutions of private law. We like private autonomy. I think capitalism would have never been as vibrant had lawyers not been able to basically use these different legal institutions to fashion new types of assets over time. When land was no longer available because the legislature intervened, all the efforts went into financial assets and legal entities. And nowadays, intellectual property rights are very hot, and of course, data are there as well. Data are protected not only in law, also through technology. So that's somewhat different, but in principle, the same logic is at work here. I'm also making the case that overall, the common law and the common law lawyers have had a comparative advantage vis-a-vis continental lawyers when it comes to the coding of capital for a number of reasons. First, the common law, as you know, is sort of governed by precedents. So the whole idea is you sort of create new types of transactions, new types of assets, and then if you challenge it in court, if you can convince for a new type of asset. So that was a really important mechanism through which we got the recognition of various transactional modes and how we could flip assets into capital. The other issue is also that England developed a very powerful private legal profession very early on. So there are already stories about private attorneys in the 13th century, 14th century. Certainly when the enclosure movement was in full swing in the 16th century, the landed elites typically availed themselves of professional attorneys to make their arguments, very often descendants of the other big families. On the continent, the private legal profession was less powerful. France controlled them in a highly top-down fashion. Prussia halved the private legal profession in the 18th century, regarding it as a threat to its own power, which is probably correct. And then, of course, we can also see in our own days, in our own globalized world, that legal education in my own law school, many other American law schools are part of that, as are English law schools. We have basically offered LLM programs and have educated lawyers from around the world in the techniques of coding capital, if you want to call it that. But certainly, most of the students who come to us take corporate law, securities law, M&A, all the stuff that you need to become a successful coder of capital. So when you look at the two global financial centers, London and New York, you shouldn't forget that they don't only host the most important financial intermediaries in the world, they also host most of the global law firms being law firms that have offices in more than one jurisdiction. I gave you only the top 20, but if you go down to 100, this doesn't look different. They're all Anglo-Saxon names. Almost all of them are Anglo-Saxon names. They result from, they're either genuinely English or American, or they have merged with local firms. I have some statistics in the book that suggest that in areas such as M&A, mergers and acquisitions, capital market law, even in large countries like Germany or France, most of the work is done nowadays by Anglo-Saxon firms or German or French firms that have merged with them. So if you want the globalization of legal practice, which is the very foundation of our global capitalist system, is ultimately a globalization of Anglo-Saxon, particularly American legal practice. Okay, so what's the issue? Is this good or bad? How should we think about this? And so here's the pitch that I make at the end of the book. I'm basically saying we do have a problem. We do have a problem, and I'm not calling for a revolution. I'm not calling for the overthrow. I do not want to have a major crisis, although I do fear that without a major crisis we can't fundamentally correct, but I do not want to live through a major crisis. I think I'm old enough to be more pragmatic, and this is why I come out where I come out. But we should recognize the dilemma. As democracies, we govern ourselves through law. That's the means that we have to govern complex societies. And we still have polities organized at the nation-state level, and that's how we govern ourselves with the help of law. In the EU, we also have delegated certain competencies to the EU, of course. If at the same time we allow private parties to opt in, pick and choose from a menu of legal systems, different laws, and still practice in different countries and jurisdictions with that law without having to bother all that much about what is happening in that country, then we're creating a tension between the coders of capital and its beneficiaries, of course the clients, and the broader quest of collective self-governance. And this is particularly acute when the outcome is such that if you know how to code capital, and if you have access to lawyers that know how to do this for you, you typically are in a much better position of wealth generation than if you're not. And so I think that's how I read our current moment, is that we get a radical response by many citizens in democratic societies that have, I think, the correct feeling that they somehow have lost control over their own destiny at a collective level and are responding. To put it very simply, I would basically also saying in the book, when you think about the Brexit referendum, they were right to rebel, and they thought that somebody took away their sovereignty, their legal sovereignty, but it wasn't really Brussels. I think it was the City of London. So you cannot make up your mind yourself. So this is how I see the dilemma, and what I'm suggesting in the book then at the end, again, I'm not saying revolutions. What I'm trying to introduce here is sort of a notion of strategic incrementalism, if you want. So I'm basically saying, let's look at how capital has done this over the years. What is it that they really need? And how can we destabilize it such that democratic collectives can regain some governance without completely destroying the system, because it has created a lot of benefits, but also assuring that we have enough scope for collective self-governance. So there's a bright line rule saying, okay, you have so much already in your hands. You have so many private law institutions that you can use. Let's just stop giving additional exemptions. For example, no bankruptcy safe harbors, or only if you do this through a central clearinghouse, but not in over-the-counter transactions. Maybe some limits on the choice of law. As you all know, the European Court of Justice has condoned the incorporation theory and basically has critiqued the seat theory for being too nationalist. But we could also argue that there are certain features of domestic corporate law that domestic countries should impose on corporations that do most of their business on their territory. I don't see what's fundamentally wrong with that. And to be clear also, there's nothing is moving, right? When we're just sending the registration documents to a different jurisdiction, the notion that this defies the free movement of persons and capital is not entirely convincing necessarily. I'm also suggesting that private arbitration has become bigger. It's very big in the United States. They use this for employment relations, consumer relations, and then ban collective action, such as class action clauses in these kind of contracts. I think we should roll this back. This will not happen under the current U.S. Supreme Court, but that's basically one of the interventions I make here. And of course, we do some preventive regulation. So the point here is basically to have a series of interventions that say, this is sort of the extra add-on that has made it possible to create capital on the scale that we have today, and we have to basically systematically find vulnerable points where we can push back and regain some scope for democratic self-governance. So let me just leave it here and listen to some of the comments, and then we can go into the Q&A. Thank you very much for your attention.